Compelling symptom of this indictment's deficiency is the government's repeated reference to trial evidence in an effort to salvage it. It should be the case.
Say that again. I'm sorry.
Certainly
Repeated.
not. The most compelling symptom of this indictment's deficiency is the government's repeated resort to the trial record in an effort to salvage it.
Not the bill of particulars?
They rely on the bill of particulars as well, Your Honor, but I would ask the court to go through the government's brief and look at their citations. And
We do.
many of their citations in defense of the indictment are in fact to the trial record. It should be the case that when alleging an indictment, failure to disclose as criminal behavior, conduct that is not inherently deceptive, conduct that may be indicative of innocent behavior, that the indictment is held to a more scrupulous and more exacting standard of pleading. But instead, what we have here is an indictment that alleges failure to disclose over an expansive 13-year period, and yet that fails to specify generic statutory language as is required by Supreme Court precedent, and that fails to identify conduct giving rise to the charge in count 3.
Is that a constitutional violation?
Constitutional violation as to counts 1 and 2, Your Honor.
What amendment are you resting that on?
5th and 6th, Your Honor.
Both?
Yes.
Could I ask, are you saying that there was a constitutional deficiency with respect to all of the counts?
Certainly with respect to counts 1 and 2.
I'm reading count 1, and you said that it failed to even generically reference the statutory language?
No, Your Honor.
I'm sorry if I misunderstood you.
My apologies if my argument wasn't clear. What I said is that even though it does parrot the statutory language, which is sufficient in many circumstances, it's not always sufficient. And there is good law, United States versus Russell and its progeny, that state that when one of the statutory terms is a generic term, such as the word event here, that the government has an obligation to state facts supporting that charge because it really is sort of the linchpin of criminal responsibility.
And the purpose would be to make sure you have notice of it, or?
That would be the Sixth Amendment purpose, Your Honor, yes.
So there's some allegation the defendant doesn't really know what he's being charged with?
That when, as the Supreme Court put it, where guilt depends so crucially upon a specific identification of fact, our cases have uniformly held that an indictment must do more than simply repeat the statutory language.
The fact is that he was getting disability payments all during this whole time, and he was working. He has a complete history of working in violation of the prohibition of getting disability payment while doing so.
Well,
What more does he need to be informed of?
A couple of points on that, Your Honor. First, the indictment doesn't lay out this work history in the way that you state that it was laid out, as we would say, in the Bill of Particulars, and
He
perhaps...
was unaware of his work history? Was he unaware of his obligation to report his employment? I thought every document he received made it clear to him that he was under an obligation to report employment, which might affect his disability benefit.
Well, if we look at the indictment, Your Honor, the only real document that the indictment points to that might have made him aware...
I was referring to the documents which he had to sign to receive disability.
Certainly, Your Honor, and the indictment does reference that he received that document. But
Right.
I would point the court to the Phillips case, because the facts in the Phillips case include reference to such documents that when the defendant in that case signed up for disability payments, that he received such sort of boilerplate warnings that he had an obligation to report any employment, and that he worked thereafter. And the court in that case...
Well, almost in every case of that sort, I mean, the documents that somebody signs upon employment are boilerplate. You're not suggesting that makes a difference, are you?
Not necessarily, Your Honor, but I mean, again, I just want to look at what the indictment...
Well, let's look at paragraph 11. And then you're right, it gives a long period of time, 1996 until 2007, and then it says Mr. Perry was employed but did not report his employment. He either knew he was employed or he didn't. What difference does it make whether the government went through and listed all of his employments? It seems like that would be peculiarly within his knowledge. He either knew he was employed or he didn't.
Well, first, Your Honor, I think we need to clarify one fact that not every employment is an employment affecting one's rights to benefits. And what the
But wasn't there an obligation to report? It wasn't, he did not have the ability to unilaterally determine what would count and what wouldn't. Did he have an ongoing obligation to report?
what the criminal statute requires is that he report any event affecting his right to these payments. And not every employment is an event affecting one's rights to payments. The disabilities statutes are a sort of vast and complex and very confusing set of statutes that say that sometimes employment will affect one's rights to benefits and sometimes they won't. And one of the reasons that it would be so crucial in this case, Your Honor, for the indictment to specify just one event affecting his right to benefits is because it would then allow a court a legal determination of whether that was an event affecting his right to
What about in
benefits.
paragraph 12? On June 25, 2007, Mr. Perry was hired by the Social Security Administration. Here's one.
Your Honor, if that's the event giving rise to this indictment, then how do we get an indictment going back to 1996?
Well, you said they hadn't set forth any, and then there's one in paragraph 12.
Well, that's not one that supports this vast, broad indictment, though, Your Honor. And I would further suggest that it's sort of tautological that he disclosed his employment to the Social Security Administration by the fact of becoming employed with the Social Security Administration. If the government had wanted to write an indictment, and let's be clear, that's really why we're here. Mr. Perry was working at the Social Security Administration, receiving employment checks from them at the same time as he was receiving disability checks from them.
Illegally. He was illegally receiving those employment checks because he didn't report them during the time he was working for them.
I would agree with Your Honor that certainly as a civil or regulatory matter, he should not have been working at the same time that he was receiving disability
And you
checks.
say the government is doing both of them. They're issuing the checks. Sounds like to me you're saying they're issuing the checks and they're employing. They ought to know they're doing both of them. That's what you're trying to say?
Certainly, Your Honor, yeah. I mean, I think the whole reason we're here is because the government's so embarrassed by the fact that they were issuing this guy employment checks.
If you had someone who was out making money and were in a federal government position and wasn't paying his taxes, then the government can't charge him for failure to pay taxes? Or if you're a government contractor, you're receiving a lump sum, you're supposed to pay your taxes on it, you say, you knew you were paying me, you should have taken the taxes out.
Well, if the statutory language at issue in that case, Your Honor, were a failure to disclose his employment to the government, and that were somehow the basis of the criminal charge giving rise to the tax evasion charges, then yes, I would continue to have a dispute with it, but I don't believe that that's the language in the tax statute.
Well, he didn't report. It is clear he did not report. Your client did not report that he was working.
He did not specifically go back to the disability side, or as charged in the indictment, because we accept the facts in the indictment as true. He did not go back to the disability side of the Social Security Administration and say, I am working at the same time that I'm receiving benefits. Did he go anywhere? I'm sorry?
Did he go anywhere and say, I'm working to him? Disability side or to the cleaning person? Did he tell anybody, I'm working?
Well, again, Your Honor, I guess I would disagree on the sort of
No, my question is, did he tell anybody? Did he report it to anybody?
Well, by filling out his employment forms and submitting them to the administration, certainly that was some sort of constructive knowledge on the agency's part.
So that is the report. He filled out an employment form, and now he is reporting that he is working. Is that your argument?
For the purposes of that employment specifically, Your Honor.
Anybody ever held that in the United States of America? Any court, anywhere, ever gone with that logic there?
Well, there are certainly cases, Your Honor, that talk about when an agency has constructive knowledge of whatever facts it is giving rise to criminal conduct, that agency is basically, as long as they have enough information that would allow them to initiate an investigation and prosecute the crime. Granted, those cases take place in the statute of limitations context, but yeah, there are certainly cases that talk about an agency's constructive knowledge of facts.
It's very hard for me to believe that that could be your argument, though. I mean, you're essentially saying that that the government is has constructive knowledge of any tax or other infractions that can be uncovered by a criminal investigation by virtue of employment. I did not understand that to be your argument. I understood your argument to be the invalidity of the indictment.
Yes, Your Honor, and I think we've gotten a little bit.
Yeah, I led
wrong.
you down that path, and you walked with me on it, and I
I
was amazed you went there with it. So
I
I suggest you get back with your argument.
I was
did-
pretty stunned by that too.
I did, Your Honor, and I appreciate Judge Duncan's invitation to return back to my argument as outlined. I would invite the court to look at United States versus Russell. I think it is an extremely applicable case, even on its facts
The
here.
problem, I completely understand why you keep running away from the facts here. But the facts here are pretty graphic. The count one says, beginning on or about in 1996 and continuing through September 2009, the defendant having knowledge of the occurrence of any event affecting his initial or continued right to payment did conceal and fail to disclose with intent to fraudulently secure payment. What did he not know from that language?
Your Honor,
He continued to obtain employment checks, which are events affecting his initial or continued right to payment. What was unclear?
Your Honor, the statutory language that I'm focused on is the word event.
I understand.
The word event is a generic term. And I want to know, Your Honor, which event is it that the grand jury found affected his right to employment beginning in 1996? Because, as we
Judge
already...
Agee suggested one.
In 1996,
No,
again...
from 1996
To 2007.
2009, I think.
Your Honor, we have an indictment that goes back to 1996. And if we say that the one fact that the grand jury found that gives rise to indictment occurred in 2007, then how do we get an indictment going back that far? And how do we say that that doesn't prejudice a criminal defendant when they have to prepare a criminal case on 11 years of conduct for which the grand jury never found even one underlying factual event supporting this generic statutory language?
Well, is the bottom line of your argument where, in practical terms, in paragraph 11 of the indictment, at times between 96 and 07, Mr. Perry was employed but did not report his employment, that the indictment should have set forth all of his employments?
Well, for the purposes of the Fifth Amendment, Your Honor, it should have set forth any employments on which the government wanted to later ask the petit jury to find him guilty of. Because otherwise, we run into two problems. We don't know what the grand jury found. That's one Fifth
So
Amendment
the answer
problem.
would be yes. The government needed to set out in the indictment all of the employments that it later intended to rely on.
Yes, Your Honor. And even if it only wanted to set forth one, and it only wanted to put one to the petit jury, that would be fine. But we don't have that circumstance here. We have an indictment covering this expansive period for which we don't know.
But what about in paragraph 12? There is one there.
So there's some renumbering in the indictment. So are you on the Joint Appendix, page 12 here?
Yes.
And again, Your Honor, I would just point to the fact that if that's my indictment, I have an indictment starting in 2007, not 1996. I don't understand what the grand jury found gives rise to criminal indictment going back to 1996, and why Mr. Perry was forced to diffuse his defense resources and his trial preparation over those preceding 11 years. If it's the case that the event that the grand jury found...
Well, you knew when the bill of particulars came out, didn't you?
But the bill of particulars cannot solve a deficient indictment. It can't save it, Your Honor.
There should have been some hint in paragraph 3 of count 3, because there's a long list of employments there. And obviously that's not in count 1, but...
And it is the law of the circuit, Your Honor, that information contained in counts that has not been reincorporated in another count cannot be sort of reincorporated in effect by the court. So the additional information provided in count 3 cannot be used to salvage count 1. But if we had if this indictment is really about the 2007 to 2009 timeframe, then that should have been the time frame set forth in the indictment. And any discussion of any evidence, any other information coming in from any prior period should have been about 404B. It shouldn't have been the indictment period based on an event that occurred 11 years after we decided he was criminally responsible. That's not a constitutionally sufficient indictment, Your Honors. That's not constitutionally concrete. Along the lines that a bill of particulars cannot salvage a constitutionally infirm indictment, the government also states that the court's ruling that this was determined to be a continuing course of conduct salvages it. The body of law on continuing courses of conduct says nothing of the kind, Your Honor. Smith, the case that the government primarily relies on, and the other cases having to do with continuing courses of conduct, relate what a continuing course of conduct does to the effect of the statute of limitations in a case. It says nothing about salvaging an indictment that is constitutionally deficient or excusing it from descending to particulars in the event a statutory term is generic.
You don't dispute that these offenses are continuing?
I don't for the purposes of this
Is there a
appeal, Your
difference
Honor.
between continuing course of conduct and charged offenses that are continuing offenses?
No, Your Honor, not in my mind. And it may be that I'm using continuing
No,
course
I'm
of
just
conduct.
asking.
Turning my attention to count 3. Oh, I see that my time is up, actually. Your
Yes,
Honor.
and you do have some time reserved for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court. Sandra Wilkinson on behalf of the U.S. Attorney's Office. Not only am I appellate counsel, but I was counsel in the proceedings below as well.
We don't often see that. That's nice.
Thank you, Your Honor. Your Honor, I want to answer the question that Ms. Martin asked first here, which is the fact that this indictment was not constitutionally deficient because not only is the indictment track the language of the statute, it goes far beyond the language of the statute and defines the term that Ms. Martin has concerns about or has articulated her concerns about, and that is the word event. And the word event in the to-wit clause in the actual charging language states that the event that he had knowledge about was his employment and his earnings. And when the Social Security Administration learns from a source other than a beneficiary about additional earnings, the Social Security sends out a work activity report asking for the entire earnings and employment record for that beneficiary. And that's what happened here, and that's what's described in paragraph 14 in this speaking indictment.
How many events did it have to allege?
Well, Your Honor, we contended at trial, and I maintain that position now, that the event is not a job. The event was the employment and earnings that he earned over a specific period of time, that being 1996 to 2009.
The fact of employment?
The
Is that what you're
fact of
saying?
him. Yes, ma'am.
And your authority for that proposition, for that definition of an event as a non-discrete?
Not that I could find, Your Honor, simply because there's not that much law out there on this particular statute that I could find. I did find other circumstances where there are other events over a continuing period of times. We talked about that in our brief. For example, the death of a loved one, continue to receive benefits for 11 years, and 11 years later, as you're still cashing those checks, that event, being the death of the loved one, affects the continued right to those benefits. Therefore, it is within Section 408. Or the event could have been winning the lottery. Here, it was the cumulative employment history of Mr. Perry that he never reported to a single entity.
Well, the distinction between the circumstances here and those in the hypotheticals you just posited are that in your hypotheticals there was a discrete event, there was a death, or there was winning the lottery. but here it appears there was just a course of conduct. The problem is that it doesn't fit comfortably within the definition of the term event as one usually understands it.
Except that, Your Honor, I was thinking about this as I was getting ready for my argument. And, for example, what if, in this case, the first job that Mr. Perry had gotten out of the box was a professional basketball player with the Chicago Bulls, and he had earned $10 million for that one season, and then he stopped, and then he continued earning those benefits for a period of time all the way up until September 2009. He was inducted to the Hall of Fame, and we find out that he had been working back in 1996 for that one event, that one time, that job. The statute is aimed at the evil of getting the money. The knowledge is that you have made earnings.
Continue to get those benefits.
Yeah, he continued to get.
He was paid $10 million 12 years ago.
Never told the Social Security, kept getting his disability
You mean
benefits.
the continued benefit of keeping the $10 million? Or
No, they kept the benefits from the Social Security, the $1,000 a month.
disability benefits.
The disability
Okay.
benefits, yes, sir. Never told anybody about his job, kept working stopped working and just kept getting his disability benefits.
What if he worked at McDonald's? He'd made $2,000, and then 10 years later, is that a continuing one too?
Yes, Your Honor. He should have told the Social Security Administration about his earnings at the time, and it might be a different case about whether or not we would prosecute that case, but the obligation is the same, which is that you must report your earnings to the Social Security Administration. This is a agency that administers.
So you cannot take an implication that he would have been entitled to certain benefits based upon the fact that he would have been required to. Does reporting it means it's going to stop automatically?
No, Your Honor. What it means is that there's a system in place, as was explained in the trial below by the Social Security employees, to get that information and determine how it does affect your benefits, which is why the statute talks about your initial right or your continuation of those benefits.
Is that part of your proof?
Pardon me?
Is that part of your
Oh,
proof?
absolutely, Your Honor.
That you have to prove that receiving these benefits would have affected the amount of disability?
Your Honor, it was part of our proof to explain why it was material to the Social Security Administration that even one extra dollar you are required to report. The whole system rises and falls on the honesty of the people that get benefits from there, just like the tax system, as the court pointed out. And that is the whole entire point. Now, whether the materiality of that lie, those are decisions in the context of other cases. Here, we have a man who worked pretty much the whole entire time from 1996 to 2007, and perhaps the only unusual fact is that he worked at different jobs during that time period up until the time he got his Social Security. But the cumulative effect of all of his earnings are what's incorporated in our definition of event in the indictment.
That sort of runs into statute of limitations issues too, though, doesn't it?
Your Honor, the statute of limitations issues are first of all, I think the law is clear that this is a continuing offense. It's focused on the receipt of the payments, and as Judge Bennett pointed out below as well, he cashed these last checks all the way after even filing the work activity report, which also failed to conceal other employment that he had. I mean, he continued to cash these checks. And that is the evil that Congress was trying to prevent when it established Section 408. When I went back and looked at Section 408 again, there are other provisions of it that talk about unique dates and time. For example, a false statement or a false representation. In fact, the first subparagraph of 408 penalizes that as well. But here, where the event could be any triggering matter that affects a person's disability, here that triggering matter is his earnings, and he had constitutional notice of it, not only because of his Social Security job, as Your Honor pointed out in paragraph 12, but also because of that reference to his work activity report, which shows employment back from 1996 to 2007. And if you look at paragraph 14 of the indictment, it specifically references that. And that was the key exhibit at trial. And I know Ms. Martin doesn't want to talk about trial evidence in the context of what is constitutionally sufficient, but we talk about that in the indictment when we're describing the event, which is employment and earnings 1996 to 2009.
He certainly was enterprising.
He was
He
indeed,
went
Your
back to
Honor.
school.
He had a lot
a
of school,
degree?
well-educated, a good employee at the Social Security benefit, and even when he had direct knowledge that what he was doing was against the law, he continued to cash those checks, might I add, even buying a new car in that time frame, Your
So
Honor.
he put his education and work experience to work for him.
He certainly did, Your Honor, and it helped to have $1,000 extra a month, every month to do it.
Well, he also received some prescription benefits.
He did, Your Honor. And part of the proof, and I don't know if the court has any concerns about the issues raised by the defense in that regard, but, Your Honor, if anything was the clear false statement in this case, it was when he applied for that low-income subsidy, where he indicated the very day he was working at Hertz that he didn't expect to earn any earnings that year. And if that's not a false statement in pursuit of a healthcare fraud scheme, I don't know what is. Court doesn't have any other questions.
Judge Duncan asked you about the statute of limitations, and I know it wasn't argued that much on the other side, but the other side concedes, at least it's for purposes, these are continuing offenses.
Yes, sir.
It says there's a problem here because you discovered it earlier. And
Well, I
once
didn't
your
discover it
discovery
early.
kicks in, then that is some limitation on the statute of limitations. Otherwise, it runs endlessly, continuously. So how do you respond to that? I mean,
Well, Your Honor, there wasn't actual knowledge. There was paperwork that suggested Social Security might have known about his earnings early on. Back in, I believe the testimony was sometime back in 1999 or 2000. But this is very similar, I was thinking about this last night, to the illegal reentry cases where the law, I believe, because I handle these types of cases, is if an illegal alien comes into the United States after an aggravated felony and the federal authorities don't find out about it, but the state authorities might have had several interactions with this individual, but the federal authorities, law enforcement doesn't find out about it, the statute of limitations doesn't begin to run until federal law enforcement finds out about it. And the same can be said here as well. The obligation is on the beneficiary to be truthful and honest. There is a mechanism for reporting your employment and earnings. He never did this. Now, if he had stopped receiving the money back in 1999, maybe we would have a different argument. Maybe we wouldn't be here today, Judge Wynn, but he didn't. And as he continued to receive that money and keep working, I believe that that's not even an issue in this case, and you don't have to talk hypothetically, because we don't have that in this particular case, is when the statute of limitations should have run, because here he continued to accept the money, never reporting his earnings from the day he walked out of the Social Security Administration, basically. Thank you.
Thank you very much. Ms. Martin, you have some rebuttal time.
Thank you, Your Honor. As Ms. Wilkinson stated, she has no authority for finding the word event to mean a 13-year employment history, none. She cited a couple of cases, or referred to a couple of cases cited in her briefs, one in which the event was the death of a loved one, or perhaps the event being the winning of the lottery. But, Your Honor, in those cases, understandably, the meaning of the word event isn't going to be at issue because there really only is one issue upon which criminal liability can hinge. That simply isn't the case here, Your Honor. We have an extensive employment history. Some of those employments may have affected his rights to payment, some of which may not. And the problem that this brings about, Your Honor, is going back to the Sixth Amendment issues, is where's the double jeopardy bar here? What is the government prohibited from re-prosecuting here? We don't know, because we don't know what the grand jury found, and we don't know. We know that there was unanimity among the petit jury, but we don't know what the event was that they found. We don't know if there was agreement among the two, and therefore we have no idea on what basis Mr. Perry might be prosecuted again.
doesn't that use of that term, employment history, makes that an easier argument for you?
I'm
I
sorry.
mean, the fact that you don't know, I mean, if they were to seek to charge something in an employment history other than what they are seeing is here, that whole definition of employment history would seem to indicate, no, you can't do that. You've already done it.
Well, because they're taking the term event and making it sort of whatever they want, I don't know that they won't take a different position in the future. and say, well, this wasn't part of the employment history included in the original indictment. I don't know, Your Honor. Giving it that flexible of a
But
meaning.
you got to feel much better knowing that they didn't allege specific dates, specific ones. They'll say it's employment history. Yeah, that would exist even if they did have specific instances.
Your Honor, if the government were to stipulate that any employment during that time frame might be barred on double jeopardy, then it might be a little bit of a different discussion around the double jeopardy point alone. But I don't think that that makes the word event constitutionally concrete such that we know what the grand jury found and whether or not that matches what the petit jury found. Your Honor, we talked a little bit, and it got a little bit light when we talked about Mr. Perry being enterprising. It sort of indicates that we don't think that Mr. Perry is a disabled human being. And I want to make sure that we're very clear. He is disabled. He has a permanent disability of AIDS. He remains disabled to this day. It's not a disability that's going to go away. The government referenced the statement that he made in connection with the low
What's
income.
the relevance of that? I'm trying to understand what that means. If you can have a disability, but if you work, you have a duty to report.
Certainly,
Doesn't
Your Honor.
matter what the disability is. If you work, and that's what this is about, is the failure to report.
Certainly, Your Honor. But I want to make sure that in the atmospherics of this case, we're all clear that this is not about a guy who wasn't disabled going out and gaming the system.
We'll try not to be a jury. We're going to stay a court on this.
I appreciate that, Your Honor. The government made reference to the statement that Mr. Perry made in connection with applying for his low-income subsidy that he didn't expect any income in the year 2007. And again, there are no facts in the indictment telling us that at the time he made that statement that it was false. There's just nothing in the indictment indicating that the grand jury knew that statement to be false when made. Therefore, how can that be a material misrepresentation? And finally, Your Honor, the last point that you touched on, the statute of limitations, Ms. Wilkinson stated that there wasn't actual knowledge on the part of the Social Security Administration of Mr. Perry's employment back in 1999 and 2000. There was, and I'm paraphrasing here, I think she said, just paperwork indicating that they knew. Well, Your Honor, if the roles were reversed here and there was paper indicating that a defendant knew a fact like that, the government would be pouncing all over it and saying it was actual knowledge. Under these circumstances, the agency should be charged with having that same level of knowledge based on its own paperwork indicating that it knew. It knew he was working.
The agency knew he was employed. It didn't know the significance of it. You would need to combine that fact with the fact of his receipt of the disability payment.
But that fact was combined on the trial record, Your Honor. This information was presented during trial where it stated that there was a flag put on his account stating, we think he is working and earning benefits at the same time.
Yes.
Thank you, Your Honor. In sum, I would just ask that the panel, when going to conference, take only the indictment with them, not take the trial record with them in determining whether or not this indictment is constitutionally sufficient. And I ask that it ask itself, what is the event that the grand jury found indictable back to 1996? And I would ask that it ask, what is the deceptive conduct that is embraced within the statute at issue in count 3? Thank you very much for your attention.
Thank you very much. We are going to come down and greet counsel. We will take a very short